everyone ready?
No, I need to ready.
Good evening, citizens, guests, council, and staff. City Clerk, let's do it.
Mayor Cernanik?
Present.
Mayor Pro Tem Beckman?
Here.
Councilmember Brinkman?
Here.
Councilmember Cole?
Here.
Councilmember Stallman?
Here.
Councilmember Stein?
Here.
Councilmember Valdez?
Present.
Please join me in the pledge. I pledge allegiance to the flag of the United States of America and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all. Council and others, note with regard the agenda for this evening, the consent agenda items are actually going to be under general business. So note that placement of those particular agenda items for this evening. And then looking for a motion for minutes to be approved.
You want to do the agenda first?
Oh, is there any other items to consider?
I don't know. I don't think so.
Okay. Yes, looking for a motion on the minutes?
I move to approve, based upon the clerk's certification, the video recording stipulated as the minutes for the 13 May 2014 council study session and the 20 May 2014 council meeting.
Second. So we have a motion and a second. Council ready to vote?
The vote is 7 in favor. The motion carries.
Thank you very, very much. And for this evening,
I have a question on the minutes. Not the minutes we just approved, but another minute.
another minute.
Another minute. And this is for the city clerk. I think it was the last regular meeting, we had changed the minutes. And when I went and looked at it just before I came down, it still shows that I voted for the sidewalk issue that we had downtown. It still shows it 6-0.
I'm sorry. I went in and I was afraid to let it go and regenerate it. Sorry. I was sorry about that. I was afraid to push it out because I need to talk to Granicus about that and see if it's going to erase all your guys' notes, if you made any notes right there.
I just wanted to reflect that it was definitely a 5-1
Yes,
vote.
I have that on my list of things
I'm going
to
to
talk
keep
to
on
Granicus.
top of that one.
Okay, I will get it changed.
I appreciate it.
Thank
Thank
you.
you. Thank you.
Thank you. And then with regard citizens appearances, we have no guest citizens, but we do have a scheduled public presentation. Former Mayor Doug Clark talking about the Littleton Riverfront Development Project and debts owed by Lyft to the City of Littleton.
Thanks, Mindy. Thanks.
Thank you.
Good evening.
Howdy.
Some of you on the council and Ann Ricker, your urban renewal consultants, have said that what happened with Riverfront 25 years ago has no bearing on urban renewal in Littleton today. This is not true. Allow me please to give you but two examples. Littleton Invest for Tomorrow, or LIFT, is spending tax money it collected in the riverfront area over the last 25 years in order to start new urban renewal projects. This is illegal. In addition, LIFT currently owes the citizens of Littleton approximately $12 million, money which LIFT refuses to pay and which you on the City Council apparently refuse to collect. This money that LIFT owes the city is separate and distinct from the monies LIFT borrowed from the bank and the bondholders. Neither the city nor LIFT shows the debt on their books. This could be an innocent mistake by those who should know better. After all, we're all human. Even finance sometimes is human. Or it could be an attempt to swindle the citizens of Littleton. My assumption is that it is an innocent mistake. But the more effort that's being put forth by LIFT and the city to deny the existence or the validity of the debt, the more difficult it is to chalk this up as an innocent mistake. Both the tax dollars that LIFT is illegally spending and LIFT's debt to the city come from the riverfront development. And let's look at that riverfront development. LIFT, as you know, is an urban renewal authority. The Littleton City Council formed LIFT under a different name 34 years ago to redevelop the riverfront area. The riverfront urban renewal area is the area roughly between the South Platte River and Santa Fe and running from Crestline on the north to Church Street on the south. Most people know the area from the failed shopping center that's on the southwest corner of Bowles and Santa Fe, which is now owned by EchoStar. What the city wanted to have happen in that area, and what's called out in the urban renewal plan, was mixed use, with low to moderate income residential mixed with office and retail. What the city actually got was a failed shopping center that sat vacant for 9 years before being turned into office space. The office space and the residential called out on the urban renewal plan were never built. The big tax increases in tax revenue for all the taxing entities that were supposed to happen as a result of the redevelopment also did not happen. The investors who purchased LIFT bonds got screwed when LIFT failed to completely repay the bonds, and the Ryder Corporation, which built the shopping center, lost about $22 million on the project. The rest of the money that LIFT owes to the city is money the city loans to LIFT for operations and to make bond payments when the tax revenue collected by LIFT fell short. The tax revenue collected by LIFT always fell short. The tax increment revenue, the TIF, collected by LIFT comes from taxes paid in the area to the city, Arapahoe County, Littleton Public Schools, South Suburban Parks and Rec District, and the Urban Drainage and Flood Control District. A portion of that revenue is divided off and sent to LIFT. LIFT's plan was to use this incremental tax revenue to pay off its bond loans, the bonds it issued, and the debt it owed, its bank loans, the bonds it issued, and the debt it owed to the city of Littleton. But the riverfront redevelopment project was such a monumental failure that there was never enough incremental tax revenue to pay the bondholders or the city of Littleton. History of Littleton riverfront is included in your handout at the very front. Now, all the money that TIF has in its bank account is incremental tax revenue collected from the riverfront area from the years 2000 through 2008. State law limits what incremental tax revenue can be spent on. It can be spent on only three things. The first thing is it could be spent on revenue sharing with another taxing entity per an agreement. Second thing is it can be spent on cost sharing with another taxing entity per agreement. And the third thing it can be spent on is retiring debt incurred for an urban renewal project that's called out on an approved urban renewal plan. The first two don't apply to Littleton because neither LIFT nor the city have any agreement with any taxing entities for revenue sharing or cost sharing, which leaves the third category, retiring debt incurred for an urban renewal project called out on an urban renewal plan. The state law limits how much tax incremental, the state laws, that limit how tax incremental revenue can be spent are shown on page 7 and are called out in the Colorado Revised Statutes. LIFT's contract with Ann Ricker is for Ann to find blight in areas other than riverfront and to prepare the documents necessary in order for the City Council to blight those other areas and to create new urban renewal plans. The work that Ann is doing in the riverfront area is not related to the current plan or to any current urban renewal project, but it's work to blight that area anew, meaning a new urban renewal plan. State law prohibits any work on an urban renewal project until the area containing the project has been blighted and until the urban renewal plan describing the project has been approved by council. The only urban renewal plan approved by council is for riverfront. LIFT is spending tax incremental revenue illegally since it is spending the money on finding blight in areas that have not been blighted and which do not appear on any approved urban renewal plan. Likewise, the expenditures of lift on staff time where that time is not directly related to work on the riverfront redevelopment project are also illegal. Now, the City of Littleton, by resolution, loaned Lyft $200,000 in 1983 on a promissory note. That note is called the 1983 City Note. You have it in your packet. Starting on page 8 shows you the resolution. The note is due after Lyft's bonds are satisfied. The City of Littleton also sold land to Lyft on promissory notes at various times by various ordinances. Those promissory notes were consolidated into a single promissory note which starts on page 11 of your handout. That note is called the 1984 City Note, and it is due 12 months after the bonds are satisfied or in 2015, whichever occurs first. Both notes were created by the City Council by resolutions and ordinances. Both notes were approved by resolutions of Lyft. All the bonds were satisfied in 2008 or 2011 at the latest, which means Lyft is in default on its city notes. Lyft has paid a total of $472,493 in payments on those notes in 2005, 2006, 2008, and 2011, although for some reason the city didn't credit those payments against the notes. When those payments are credited against the city notes, the remaining balance is approximately $12 million. The city seems to maintain that the debt is not only not valid, even though they've not been able to produce any council resolutions, motions, or ordinances that alters or rescinds the notes. They cannot produce any memos, letters, notes, or other documents between the city staff and Lyft changing the terms or modifying the notes. And this is shown on page 14 of your handout. In 2008, the 2008 CAFR claims that both city notes were discharged in December 28 per bond documents, even though Lyft bond documents have no legal authority over a promissory note between the city and Lyft. This is like you writing into your car loan documents a note that your home mortgage is discharged on a certain date and then claiming to your mortgage company that you don't owe them money because of the note that was in your car loan. The bond documents have no authority over debt between the city and Lyft. The City Council never approved those bond documents. In fact, they never saw the bond documents. It's inconceivable why the city or Lyft would claim in the 2008 CAFR that Lyft could unilaterally change the terms of its debt to the city without the City Council's knowledge or consent. So, what we are asking you, the City Council, to do is three things. We're asking you to instruct Lyft to stop illegally spending incremental tax revenue, which includes expenditures on its contract with Ann Ricker and the executive director and any other staff members. You have the authority to remove Lyft members for cause if that's necessary. Second thing we're asking is that the City of Littleton collect the debt that's owed to the citizens of Littleton by Lyft. This should start with Lyft paying the city about the $140,000 or so that it has in its bank account. The third thing that we're asking is that the City Council not approve any finding of blight for any urban renewal area, and it not approve any urban renewal plan unless that plan calls for Lyft's debt to the city to be completely repaid before Lyft incurs any other debt. We believe the City of Littleton cannot afford any new urban renewal debacles like Riverfront.
Doug.
The city is currently out millions of dollars.
Another sentence.
Okay. Thank you.
Thanks, Doug.
Thank you, Doug.
Thank you.
Certainly your perspective is one where we share the concern for the prudent use of citizen and taxpayer money. One issue that I think is still being looked at is, I believe, your motion in 1999 for the refinancing of the debt also had a provision in it for the remaining debt to be extinguished in 2008, and that was the part that came across from finance in 2008. And I recall that from some of our audit discussions that you and I were on the audit committee in 2009 looking at that. So, but do appreciate that. Okay, Council, now we move to the unscheduled public appearances. Unscheduled public appearances are an opportunity for any citizen to express opinions or ask questions regarding city services, council policies, or other matters of community concern that are not part of the scheduled agenda. Generally, an immediate response should not be expected. Typically, issues are referred to city staff for follow-up information or research and reported back to the council and the individual that initiated the comment or inquiry. If any citizen would like to speak during unscheduled public appearances, please complete a green card, and they're at the back table, and give that card to the city clerk or leave at the podium. And this, there's a 4-minute time limit. Thank you, Wendy. And please state your name for the record when you do come forward. Second, stop.
There we go.
I'll get it here. And would anyone like to come forward? Mr. Watson.
Yes, sir. John Watson, 4500 West Hinsdale, Littleton, 80128. Mayor Clark's presentation was excellent. Mine was independent of his. I just wanted to present an owner's perspective on condemnation so you'll know what you're about to undertake when you tell people they're going to be subject to condemnation in the city of Littleton for some social engineering project. I've had that happen to me 3 times. 2 were successful, 1 not, and wanted to talk about how that works from an owner's perspective, and maybe that'll explain why people aren't lining up at the front door when you hold your meetings telling them they're going to be blighting their property. The mantra is that the city pays fair value. Now, that would be great if that were the only issue, but frankly, in the 3 times I've been subject to a condemnation, it means that the city, or in my case, the state, DOT, and the state of Colorado again, means they're going to decide who to call as an appraiser, they're going to pay the appraiser, they're going to get the appraisal, and they'll decide when and if you're going to get paid. They base your value on prior zoning when they're not bound by it. So, for example, if they're going to take your property, which is going to be an industrial property, turn it into a retail property, does this bring to mind any examples? They're not going to pay you for retail property. They're going to pay you for an industrial property based upon a prior zoning with no consideration whatsoever of what you were going to use with the property. Finally, they don't pay your soft costs, which means if you've incurred plans for a zoning change, for an engineering change, building improvements, any plans or engineering, a cleanup, or had litigation expenses or taxes or maintenance or repairs or insurance or rents or replacement costs that you've incurred during the interim from the time that they've started their blight study, you're eating it. So, for example, if you had plans for a development at 40th and 40th and you spent $250,000 for it and did a zoning change with the city and county of Denver, guess how much you're going to get paid? And it's a single-digit round number. So that's the experience of an owner when you go through a condemnation process. Maybe that'll help you understand why they're not lining up at the door to see what social engineering we're going to have for them. Let's talk about what happens to tenants. The mantra is that they pay the relocation expense. Well, let's see how that works. Do they include a name change? For example, if your name is Blake Street Wood and they're moving you to Commerce City, do you think that's going to help you very much? Are they going to take care of that? No, that's a soft cost, of course. Do they give you consideration for a location preference if you're in downtown Denver when they move you to Commerce City? You already know that answer. They're going to move you to the cheapest, easiest place they can. Does it include the compensation for loss of customers or setup if you have drill presses or cranes or overhead costs? No, doesn't pay for that. Let's talk about how you can own a property during the condemnation process. Let's say, for example, it starts in year 2004 with a vote in the city and county of Denver, and without your knowledge or consent, they post your property with a notice. For example, a blight notice. Or they take pictures of your property without any prior knowledge or consent and post it in city offices, subjecting it to a blight consideration. What does that do to your property? Well, I know. I've been there. You can't refinance if your loan is due. You can't sell it to anybody because you're in a blight study. You can't lease to the tenants because they don't want to be in a property that's going to be condemned and taken away. You can't remove their signage, which impairs your value. I've had insurers refuse to insure it because you've blighted their property. My property's been blighted. Had to change insurers to pay assigned risk insurance. But guess what you do get to do as an owner? You get to pay the mortgage with no tenant income, repairs, insurance, maintenance, taxes, default expenses for your loan that's come due, and your utilities. Pretty swell concept. Let's talk about what the city gets out of it for urban economics. Owners forced to sell, find a replacement, pay the taxes on the sale, and lose money in a forced sale based upon their prior experience. The city takes money out of the property rolls, and now you're going to have the schools lose money, the parks lose money. It gets better, but my time is up.
Thank you, John.
Sure.
Anyone else? Mr. Mitchell.
Mr. Mitchell. Dave Mitchell. Depending upon how City Council handles the issues that Doug Clark brought up, this two comments that I have may not be relevant. Ann Ricker on March 18th made the following comment that Riverfront was a success. Was that made with knowledge, or was that shooting from the hip? California started the concept of TIF. California has the most experience with TIF. California state legislature no longer allows TIF financing.
Thank you, David. Anyone else?
My name is Linda Knufinke. I live in the 4th District. Oh, that's my dog. Anyways, I didn't know that the dog was on this drive. Anyways, I would suggest that you think through the impacts of blighting so many properties. The total number of properties identified to be blighted by Ricker Cunningham is 425, and that's for a total of 744 acres. So is it too much too soon? Consider blight expenses, consider condemnation, relocation, court costs, administrative costs, interest expense, bond expenses, and expenses are always higher than you anticipate, and the authority will end up buying property from property owners in order to aggregate those properties. So the Riverfront Authority condemned every single piece of property they had, and they bought out all the property and the business in the and all the businesses in the riverfront area. They even had to buy a right-of-way from Denver Water Board. The identified properties to be blighted represents about 2,402% increase in the number of properties that the Riverfront Authority did. So this is it's a huge project. And the total number of properties listed to be blighted represents almost 10% of the total acreage in the city of Littleton. So an example of the implication of blighting properties is King Soopers. And King Soopers hasn't been even built yet. So back in 2013, you entered into an agreement providing for $381,000, $319 in sales tax shareback. The city will share the sales tax with a 50-50 split, resulting in no net revenue loss during this agreement period. That is until the TIF comes to play. So the King Soopers development agreement, I would propose to you a scenario. So the King Soopers closed in January of 2014, and by the way, King Soopers is slated to be blighted. So they closed in January 2014. Their sales tax revenue in 2014 is zero. So the blight say the blight is approved in January of 2015, the TIF-based revenue is based on the previous year sales. So all of your incremental revenue in 2015 goes to the TIF. None of it goes to the city. The city receives no sales taxes from the property, and the city must backfill the lost rebated revenues from the general fund. So my suggestion to you is follow the money. The riverfront's financial history shows that the TIF funds are not free money. The notion that your taxes won't increase is fundamentally flawed. The TIF's basic premise is that property taxes will go up for the impacted properties. That may or may not happen based on the economy. Remember, your property taxes probably will go up anyways. But what the TIF does is it takes money and redistributes the funds to increase the services that'll increase the required services that are needed to be provided to the citizens, and revenue to the government decreases. So you should have additional police, fire, code enforcement requirements without the ability to pay for it all. So where does the authority take money from? It takes money from the schools, Littleton schools, Arapahoe County, South Suburban, urban drainage, and developmental disabilities. Oh, I'm sorry. And so the impact of redistributing. Sorry. So the police and fire and city staff may not be able to get raises. Social services for the county can be impacted. South Suburban has less money. So what we did is we looked at the Littleton Public Schools and, sorry. That's why I do PowerPoints. So based on Arapahoe County tax rolls from 1986 to 2009, Riverfront Authority took $4,737,436. So we, the taxpayers, paid these taxes thinking it would go to the school. So thank you.
Okay. Thank you, Linda. Anyone else? My terrible Spanish, Señor Trujillo.
Good evening, members of council, ladies and gentlemen. My concern here tonight is the fact that on the Broadway proposition that swings all the way towards from Broadway on Powers, it goes down the street and it takes in 4 units there. One of them is mine, my neighbor, and the 2 neighbors there. Our concern is that this is done in order to facilitate the 52-unit housing that was voted out by the people of Littleton. But we keep thinking it's going to come back just like a tornado and get us again. So that is basically why we are very concerned why you are outlining our residences on this. I don't think that, what I'd like to say is that our District 2 people have fought and fought and fought for what they think is right up there. We've won some good ones, but we think that this will bring it back again, and that it will create another problem where we have to go back into battle again. So we feel that the council should take a look at this and see whether or not all of the required residences that are on this, are they really a requirement for something, or are they just put there so somebody can look at them and say, well, that's a pretty good deal right there, because right next to it you have the property that belongs to the housing authority that wants to build 52 units of low-income housing, and our district has more than paid their share with low-income housing and our share of apartments. So we are concerned about this. We want you to take a good look at it. Thank you.
Thank you, Joe. Anyone else? Ms. Breezak?
Can I give you a green card retroactively?
Thank you.
Okay. I'm Carol Breezak. I live in the 4th District. When I first heard about the possibility of the Urban Renewal Authority being revitalized in Littleton, I decided I had to learn what I could about an authority. So I attended meetings and read the minutes of their meetings going back to 1980. In the end, the only way for me to really tackle the level of understanding I desired was to document what actually took place. The result is a document that summarizes the entire Littleton Riverfront Authority history based on their meeting minutes and resolutions. It's an 86-page document. I have posted this document at littletonviews.wordpress.com. Anyone can go there and read. I do recommend reading and rereading this document. If you're like me, you will find it alarming, confusing, mystifying, and in the end, you will have more questions than answers. It is alarming because their financial estimates were not even close to their actual expenses. The Riverfront project was not supposed to cost the taxpayers of Littleton any money, but it did. The authority was not going to use eminent domain or condemned property, but they did. The city loaned money to the authority and is yet to be completely reimbursed. The city sold the authority land, which they sold. However, they did not use the proceeds to pay their debt to the city. Confusing because all of the financial maneuvers, lines of credit, note to the city that gets consolidated with another note to the city, bonds issued to refund previous bonds and more bonds issued to do the same, and bonds sold from the bondholder to a private party. A promissory note that is supposed to be forgiven, but there's no record of such action except in the authority's minutes where it's mentioned that it happened years ago. Mystifying because the 2010 and 2011 minutes indicated a desire to dissolve the authority because their obligations are settled. But in 2010, they continue at the behest of Jim Taylor, who tells them that there's been discussion about starting up again as an option to help owners of defunct shopping centers in the city. Then in 2011, they remain active because Taylor wanted to go another year to see how the new city manager might feel about reactivating the authority, since there would be a tax advantage to underperforming shopping centers if there was a threat of condemnation. So the authority keeps the $142,000 in TIF money for another year to see what the city manager wants to do. Never mind, it's the council's decision to make. In December 2012, the city manager does tell the authority he wants them to remain intact. He saw upcoming development and redevelopment and the possible use of eminent domain in the future. He mentioned the INSA property, the Marathon property, the old Safeway on Broadway south to Powers, and with the first development likely to be the property at Bellevue and Federal. I'm mystified that members have served on the board for over 25 years. The excessive executive sessions in violation of the open meeting laws, retreats without minutes in the record, a 3-day retreat that resulted in less than 2 hours of meeting, a meeting held in the home of the chairman. I'm not really sure how I feel about this one, but I can tell you that I'm weary. It is not the place of citizens to have to point out to you the requirements of the ordinance establishing the authority, but here I am. I'm referring to the original ordinance that established the authority, 63 from 1980. According to the ordinance, the authority is required to have a council member on their board, but they do not. Why is that? So we have an improperly constituted authority spending TIF money collected to fund the Riverfront Festival Center that's being used to pay an executive director, an attorney, and a consultant to go and find blight in Littleton. And because blight is so easy to find, we now have 744 acres of consultant-recognized blight in Littleton, including the King Supers that is in the process of being rebuilt, Breckenridge Brewery that is just breaking ground, and the riverfront itself. Am I the only one that thinks there's something very bizarre at work here? Thank you.
Thank you, Carol. Anyone else? Mr. Brown.
Good evening, Council. Been a while since I've been down here. I couldn't track through all of those things if I had another lifetime to take a different path in education and the mental acuity to do so. Having lived here, having seen what went on, there was a grand plan for what happened at Riverfront, and it didn't work out. Sometimes it's external things, the economy. Sometimes there's just too much cheerleading, everybody's excited, and the plans aren't credible. I believe there was a lone voice that suggested last time this retail plan isn't really going to work. Those of you with the financial background, I expect you to be able to understand this and not cause the same problem again. A property that sits vacant for many years, that might be a marketing issue, but there's been a lot of financial details thrown out. Going forward, I think you guys own this because you reinvigorated this, renewed it, whatever it was. So as a longtime citizen of Littleton, I like Littleton. I'll be moving out of Littleton, but please take care of Littleton. Do what you can to do the right thing. And I guess if I encounter you, I'll remember who is on council now. You've got a lot of the same people on LIFT that were on the Riverfront Authority, and that concerns me. If you didn't have a credible, a good outcome the first time, it seems to me that you wouldn't keep the same team in place. But maybe they learn from their mistakes. Again, you guys, please be careful. Do study it, and now that it's started, please do the right thing. Be careful. Thank you.
Thank you, Norm. Anyone else?
Good evening. I'm Dave Schwann, District 3. I'll get it right. I went to the open house for LIFT, and I looked at the maps, and I was impressed that some of the blighted areas were just empty fields. So I asked, why is it blighted? Inadequate streets. Well, if it's an empty field, it doesn't have streets. And so that's blight? I'm convinced that Rinker could blight every piece of property in this city, and without trying very hard. Second, if an urban renewal authority with condemnation and reducing taxes available to the county and the schools, parks, etc., is such a wonderful plan, then I think you ought to take it to the people and sell it to the citizens of Littleton and have them say, yep, this is a great thing. Look at how well Riverfront worked out. Where's our $12 million? Thank you.
Thank you, David. Anyone else? Seeing no one else, we'll move on to, we have no consent agenda items, as I mentioned before. We move to the ordinances, and this happens to be one on second reading, which is an ordinance on second reading conveying by quick claim deed the city's interest in a drainage and utility easement to the private property owner. Director Bloston.
Do you need to read the ordinance?
He read the title.
Okay. City Council, this is a simple matter of an ordinance that would vacate 5 foot of an existing 10-foot easement in a newly platted area called the Overlook Plateau. By mistake, the engineer drew it as a 10-foot easement, and there's only a 5-foot one required. All the utilities that are would be within that area have agreed to the vacation proposed. If you have any questions, I'll be glad to address them.
Council, any questions? Okay. This is a second reading. We will open the public hearing. There is no one registered at the moment. Would anyone care to come down and comment? Seeing none, we will close the public hearing. Council, I'm looking for a motion.
I motion to approve the ordinance authorizing conveyance by the City of Littleton of its interest in a drainage and utility easement on Lot 6, the Overlook Plateau, on second reading.
Second.
Okay. We have a motion and a second. Any discussion? Seeing none, Council ready to vote?
The vote is 7 in favor. The motion carries.
Thank you.
We're a chatty group tonight, aren't we?
Yes, we are. Must be the warm weather. Okay, Council, we now move to what had been previously noted as consent agenda items are now as general business. First item up is Ordinance 14-2014, Version 1, which is an ordinance on first reading concerning the regulation and licensing of retail marijuana establishments. This one has a policy question. Does the City Council want to permit retail sale of marijuana in Littleton? Or does they want to prohibit? I'm sorry, I read the wrong one first.
Yep. Could you read the other one first?
Okay. And is staff going to make any presentation?
If you do ordinance 13 first, that would be great.
13-2014.
Yeah, 13-2014, yeah.
Thank you.
Got it.
I'd like to make a motion, Mr. Mayor.
Yes?
I move to approve
I'm sorry to interrupt. Just
Yes.
for the record, would you please read the title of the ordinance into the record of 13?
The title is an ordinance on first reading prohibiting retail marijuana establishments.
Thank you, Mayor.
I move to approve ordinance number 13-2014 prohibiting retail marijuana establishments on first reading and a public hearing be scheduled for July 1st, 2014 at 6:30 p.m. in the council chamber. I also move to deny ordinance number 14-2014 concerning the regulation and licensing of retail marijuana establishments.
Second.
Okay. Council, we have a motion and a second. Discussion? Questions? Okay, I'll be the lone comment on this, seeing no one raise their hands. I'm a bit torn around some of this. What I'd like to do is actually see us make sure that we have the requirements around any retail that we would tend to permit, and would like us possibly to continue additional discussions. So you may see me vote against this particular motion at this point in time. So. Any other comments or discussions?
So would you clarify for me? We just had reference to two different ordinances in one motion?
Yeah, I will repeat the motion if you want that.
I'm not understanding how we would have two at once.
We crafted if the council were to approve the ban, ordinance 14 is null and void at that point. And so the way we crafted the motion, if you have a ban, you don't need the ordinance authorizing retail marijuana. And so the motion would take care of that in one.
And part of the reason for that is, if you recall, Councilmember Cole, at our last discussion, our direction to staff had been to craft an ordinance allowing for that, restricting the distance requirements and locations. So that's why it asks for not just a positive motion, but also denying the other motion.
So if we oppose the one and favor the other, this is the time to say so, because it won't go forward at all?
Correct. At this time.
That is correct.
It'll go to a second reading? No.
Yes.
Yes.
It is an ordinance.
Right. So what is on the table, let me clarify, is a motion to approve prohibiting retail in Littleton.
Well, I'm a little confused. In the past, when we've voted essentially against something, it doesn't go forward. But what we're saying is the prohibiting, we're voting for prohibiting, so it does go forward in a weird kind of way of thinking.
If you go back to the Amendment 64 requirements, and what cascaded out of that is we would have to take a positive action to prohibit retail.
So if we want this to go to a second reading, no matter how we feel, we have to vote yes.
If you want it to go to a second reading, correct.
Can I just ask for a clarification? When you say, Councilmember Cole, when you say if we want this to go to a second reading, which ordinance?
Well, we have two.
Right, there's an ordinance to prohibit, that's ordinance 13, and there's an ordinance that would allow limited retail, and that's 14. So if the ordinance to ban passes, de facto, you have to move to reject the other one. That's the motion that is pending. Both of those decisions within one motion will go to a second reading. If, I suppose one option for the council, if this motion fails, would be to then move on to Ordinance 14 and determine that on the merits. Well, it's on first reading, so it would be to continue that process. Then we see if that passes and goes to a public hearing there. So either way, you're going to have a public hearing at the next council meeting to talk about the decision to ban retail or the decision to move forward with an ordinance regulating limited retail.
So either way, we'll have a second reading.
Yeah, it's just a question of a second reading on what, and the motion on the floor now is a motion to ban retail, which by its nature would mean that Ordinance 14 would be rejected.
And I'll make a point on this, which is if we actually voted down 13 and voted down 14, the moratorium would just continue.
Right. You still have a moratorium, and that deadline would just be a little bit closer.
Yes.
Well, I thought I understood until you're next to the last sentence.
Our moratorium is up October 1, so if we voted both 13 and 14 down, the moratorium still remains.
Changes nothing.
Right. Changes nothing.
So we say again, so if I want to have a hearing, how do I vote on this? I'm sorry, I'm really confused by having two things that are contradictory.
Right. Well, we have two ordinances that are contradictory, which means if one of them passes, the other one has to fail. Theoretically, as the mayor pointed out, they could both fail, and then the moratorium stays in place until the end of October. But if the ordinance to ban passes on first reading, then on July 1st, we will have a public hearing on second reading on that ordinance to ban retail marijuana. If the ordinance to ban fails on first reading, and then we move forward to Ordinance 14, and if that passes, then we will have that on public hearing.
I must have misunderstood. I thought both of them were coupled in the councilman's motion.
They are in his motion to pass the ban and therefore reject any further consideration of Ordinance 14, which would allow for retail.
Okay, I missed how that was phrased. Okay, right. So if I wanted to go forward, I have to oppose his motion. Is that right?
If you support the retail, then you, right.
Just to be clear, when you say...
I hope somebody else was confused. Geez, sorry.
I'm sorry, now I'm confused. When you say I want it to go forward, the motion on the table is a motion to ban it. If you're saying if I want the motion to, if you want the process whereby we're going to go to second reading on banning retail marijuana, that being it, then you would vote yes. If you favor a further discussion about retail marijuana at a second hearing, correct me if I'm wrong, then you would vote no.
Right.
So I don't know when you're saying it, I don't know which end you're talking about.
I got it.
Okay, thank you.
And just, City Attorney, if you'd repeat something that you said early in the discussion, Amendment 64 has a requirement that it be, and you talked about it being a positively stated motion. Can you clarify that? Because we're in this swirling mix, not because of our own choice, but because of the wording of Amendment 64.
Well, I can't take credit for the mayor's wise statement, but I can say he was correct. But it was a mayor who correctly pointed out that Amendment 64 basically gives local governments the authority to ban retail, but that must be done by an affirmative action. So hence the ordinance that's under consideration now is you are taking an affirmative action to ban retail if that is what the will of the council is.
Thank you.
Thanks, Peg. I was pretty clear where I was when I walked in the room tonight. Then you helped confuse me. I'm not an attorney, but I think if I were to rewrite this, I could write it in like a quarter of the sentence. It would just, if you don't want in the city of Littleton, vote yes. I mean, and that's what it is. That's what we're voting on.
Say again.
Period. If we do not want retail in the
Right,
city of
gotcha.
Littleton, you agree with it and say yes. And if you
Or if you
and
wanted
if you
to go to a
do want to
hearing.
consider it at least, that's where the other one comes in.
Or if you want a hearing,
I don't want to hear it at all. I'm ready to vote no. Let's go.
Okay. Further questions or discussion, Council? So, Council, the motion is to approve the ordinance prohibiting retail marijuana establishments. This is on first reading, and a public hearing will be scheduled for July 1, which is our next regular session, at 6:30 in the Council chamber. Paired with this is a motion to deny what we have provided some direction on is the ordinance number 2014-14 concerning the regulation and licensing of retail marijuana establishments. Council ready to vote?
And you should say what a yes vote is and what a no vote is.
Okay, a yes vote is to prohibit retail marijuana at this point in time.
Cool, thanks.
The vote is 4 in favor with Councilmember Cole, Councilmember Cernanik, or Mayor Cernanik, and Councilmember Valdez voting no. The motion carries 4-3.
Okay. Thank you, Council. That completes our general business section for this evening. Consideration of authority, board, and commission matters. Two items I wanted to mention in that is we will have the Historic Preservation Board with a study session next Tuesday, June 10th, and also the invitations for the Boards and Commissions Appreciation Dinner have been sent out, and that is the evening of June 26th. So on that. So other comments and reports, City Manager.
Thank you, Mayor. You hit a couple of them there. Also remind Council that on June 5th, this Thursday, you've got Council Breakfast with businesses. We'll be emailing you out. That's at 7:30 to 9. We'll be emailing you out those businesses and a little bit about their background prior to that meeting, and then have hard copies for you as well. And then on June 10th, the Mayor mentioned Historic Preservation Board, a joint study session. We're also going to have C&B, the walkabout that you did downtown. They're going to come with their final presentation for the downtown wayfinding program. And then a reminder that June 17th, you're at the CML conference, so there will be no meeting that day. And lastly, on June 26th, we've got the council with coffee at Spur, and that'll be council members Beckman and Stallman at that one. So, and that is all I have this evening, Mayor. Thank you.
Okay. Councilmember Stein.
Just to briefly touch on what Mr. Penny mentioned a moment ago, the signage and wayfaring project, which I think is very exciting. Members of council and there's another committee that's been working with C&B, which is a consultant who has done a design, several designs which have been on the website. Some of you have seen it. Some of you have commented on it. It will go through one more presentation tomorrow at the Downtown Merchants meeting, and then be posted again. I think it's going to be a very interesting way of raising the awareness of some of our downtown merchants, as well as some cross-referencing between the open space and the downtown area. So I'm very excited to see that move forward.
Okay, thank you. Councilmember Brinkman.
Wanted to let council know about a project that I've been working on. I met with Margie at Aspen Grove a month or so ago, and during part of our conversation, we were kind of discussing some options and different things that we could do at Aspen Grove. And I recalled when we met with Arvada and discussed their urban renewal that they have a public library downtown, and the amount of people, I think it was something like 11,000 people a week or a month, I can't recall exact, that were pulling in, and how valuable and great that was. So the thought then became, what about putting in a branch of Bemis Library at Aspen Grove in an empty storefront? So that gained some traction with DDR and with Margie, and I have talked to Tim and City Manager Tim Nims, the director of the library and museum and the city manager, and we are looking at how we can continue to explore that option. DDR is looking at contractual arrangements that they have with their existing tenants to make sure there's nothing competitive there. And Tim is looking at some of the practical application of, adding a second library, kind of an express library. It's a new model that's being used in a number of cities. It's very successful. And then putting together some numbers on budget. And this would be a no lease. The city would be given the space. And it would provide, I think it would be, clearly the benefit would be to draw an additional element to Aspen Grove, create an additional amenity there. We don't have it's a far enough distance from Bemis that I think it would be a practical convenience for a lot of the public. So anyway, just wanted to let you know that we're working on that, and we'll be getting back to council once we have some of the particulars and details, specifically budget and stuff like that put together.
Great. Thank you. Councilmember Valdez.
Yes, a couple months ago I'd asked about the planning board meetings being canceled, and again today I went back and looked at it, and 50% of their meetings have been canceled over the past 21 meetings. All this talk about condemnation and blight, and yet the planning board is doing nothing. That concerns me a little bit right there. And I, as the District 2 representative, I keep hearing District 2 being brought up, I would hope that that LIFT or the Housing Authority or any other organization would bring me into the loop if they are indeed looking to condemn property in District 2 and rebuild something. So I'd be very disappointed if I weren't brought into that loop. I have one other thing I'm going to bring up on the museum board.
Okay, can I make just a quick comment on that? Because and I'd also point this out to anyone that's listening. Take a look at the PowerPoint page 91. That's in the lift-littleton.org website. It's the LIFT website, and it talks about the next steps. So there is so many steps between now and when anything is even considered for blight. So LIFT has to go through a lot of steps before they bring anything back to the planning board. So the planning board doesn't have any activity till LIFT actually goes through the effort, and the areas that they've been looking at are study areas. They are not urban renewal areas, they're study areas. So they haven't put in any particular boundaries yet on any of that. So their next meeting, I think, is June 16th?
Yes.
Which is a public meeting. So it's posted on the website. And then for other folks, some of the questions that people have come up with, and not that they're all answered, but they also have a Q&A that's on the website, that particular website. So take a look at it, and you'll get some additional background. So just as a quick piece to...
Well, since you threw in some more, I'm going to throw in some more.
Sure.
I was not opposed to disbanding LIFT a couple of years ago. They had no work to do. The riverfront was a mess, and they didn't pay us money. So I had no problem. And now all of a sudden they're kind of being resurrected to do something else. I guess I need to get up to speed with what's really going on here, because we have so much talk about what they're doing now, when I thought they had to be convened for a particular purpose. But it looks like they're going out and doing studies, and they're going to come to us with what they would like to do. So it's a little mind-boggling to me right now.
Yeah, and my only comment would be on that, which is they didn't know they would have anything until they actually did the studies. So that was part of it. So,
well,
yeah.
I have one other thing on the museum board. They were just awarded the TripAdvisor, which is a prestigious award recognized for businesses that consistently earn top ratings by their visitors. And I think most of those visitors that vote on that, of course, are TripAdvisor members. Also, they have 4 new lambs, and more are on the way. They don't have any new piglets this year. They are good at making lambs, but they're not so good at making piglets this year. So it was interesting because the lambs are born a little bit later this year. Usually they're born when it's a little colder weather, but they kept the rams away from the ewes. Is that what it is? And I don't think those rams are too happy about it, so now there are all kinds of little guys coming out. So also tomorrow is the beginning of the museum's concert series, the summer concert series. Tomorrow, 7 o'clock, is the Denver and District Pipe Band. Let's see, right now their exhibit in the gallery is the Spirit of Community and Kids Connections. But the exhibit that I'm really excited about that's coming up, and let's see, that's going to be the new exhibit, will be starting July 5th and running through August 16. It'll be Littleton Goes to War 1991 through 1995. And I was over there just last night, and I got to walk around a little bit. It takes 2 months to set up this exhibit. It's going to be a pretty cool exhibit. Let's see. Also, another subject, this one involves Bemis, more or less. A patron that went over to Bemis the other day saw that Clifford, the big red dog, was also at the library, and this patron, went ahead and went on her phone and went to next door and put it out there, and sure enough, a few folks came back and were excited to get their kids down there. So that I think if you really want to find out what's going on, kind of like right away, I think it is helping a lot of people on the next door communications there. That's really working out well. Let's see. I think I had one more thing. Sorry. Let's see. At ACC Sunday, June 8th, that's this Sunday, is the Exotic Car Show that's going to benefit Colorado Cerebral Palsy, which is now named Ability Connections. Really, I encourage folks to get out there and hopefully we'll have good weather. And I know the Littleton Block Party is coming up, but I think it's June 14th or something like that.
June 14th, and that's also the same day as the fire muster in the morning.
It's also the same day I'm going to a wedding.
Councilmember Stallman.
Thanks. Let's see here, attended the LPS board meeting on the 29th of May. The two predominant items that were discussed were a legislative update, talking about a variety of issues, not the least of which is potential turnover in the legislature and getting potential new legislators up to speed on education issues. Budget issues regarding the negative factor, which is still quite large, notwithstanding. I believe there was 100 and some odd million dollars that was allocated to bring it down.
Only a tenth.
Not too long ago. So forth and so on. And then the proposed 2014-2015 budget was also discussed, and I won't get into that. It's on their website if anyone has an interest in that particular document. There's a plethora of details. I'm going to Jerry started going down that road, but I want to make a couple of comments concerning the presentation from Mr. Clark and a lot of the follow-on discussions. In 2002, over 100 companies wrote off about $135 billion of goodwill as impaired in accordance with accounting standards. 135 billion with a B is an awful big number. In the ensuing 10 years, and I should point out that that 135 had to do with mergers and acquisitions that were conducted prior to 2002. In the succeeding 10 years, from 2002 to 2012, over roughly $7 trillion of mergers and acquisitions were undertaken in the United States, and that includes the downturn in 2008. The decisions that led to the $135 billion of impairment charges were presumably good decisions, well thought out by corporate leaders and boards of directors, presumably with the intent of creating shareholder value, but they had bad outcomes. I mean, nobody goes out and decides they're just going to waste $135 billion. Presumably there was some substance that said, these are good ideas. A lot of them were lousy ideas. Didn't work out, didn't happen. You know, we all lived through a lot of that. A lot of us were involved with companies that were right there in the thick of it. The details surrounding the Riverfront Authority, now LIFT, are obviously extensive. They're old. They're 15 to 30 years in the past. It's not to say that they shouldn't be paid attention to, and clearly a lot of people have done an exceptional amount of work in terms of digging in and trying to understand what happened and so forth, you know, what can be gleaned from that point forward. I think that's a worthwhile activity. I'm concerned a bit, maybe more than a bit, about, though, the use of some provocative words that are being thrown around just at the outset here. I mean, we're on step 8 of 257 steps before a project could ever come to fruition. There'll be plenty of opportunity for public input. There'll be plenty of opportunity to debate, deliberate, discuss, assess, opine, and investigate. But throwing around words, you know, blight is a technical term. We all understand that. You guys understand that, and I understand you're using it to prove a point. Condemnation, it's a tool, but nobody's out here saying we're automatically going to start willy-nilly condemning property. Illegal, prohibitive executive sessions. I mean, these are loaded phrases that have been reviewed and discussed and have been subject to a variety of attorney input over a period of time. And it raises a concern that minds are made up before we're even close to getting all the facts on the table. Ultimately, the decision to proceed with an urban renewal activity, of which there are many, many examples around the state and the country that have been successful. And more to the point, if Riverfront had proceeded as the intent of the people who were all involved in it some 25, 30 years ago, we wouldn't be having any of these conversations today. It presumably was a good decision that had a bad outcome, and I think Norm Brown was spot on. It didn't work out. I think we're all sitting here wishing it had worked out because we'd have more money in the bank, we'd have better roads, we'd have better services, so forth and so on, but it didn't. I guess I'd ask City Manager Penny, my understanding of what was done was that there was an intergovernmental agreement that was agreed to in 1999, that Mr. Clark was involved with, that, and I think the mayor alluded to, that effectively everyone agreed, or it was agreed by council to extinguish the debt in 2009. Is that, or in 2008, is that an accurate representation?
It's not quite as clean as that, and I would ask I think the city attorney would probably best respond on that piece.
Please.
Councilmember Stallman and Council, the 1999 indenture agreement, which refinanced the bonds, had very clear language in 2 or 3 places that indicated that if the debts, and that would be the bond repayments and the note repayments, were not paid back by December 31st, 2008, those debts were permanently extinguished. It would appear, I certainly wasn't there, some of you weren't there, I'm assuming that the participants in that transaction understood the consequences of the terms of the refinancing. One of the reasons some councils have a city council member serve on an urban renewal authority is to serve as a liaison to that board and to keep the council informed as to what the urban renewal authority was doing. The motion to approve that indenture, which by its language said these debts are extinguished if they're not paid back, whether or not they're paid back by December 31st, 2008, was passed unanimously by the LRA, and Commissioner Clark made the motion to approve it. I don't know what he told his colleagues on the council about what the impacts of the refinancing would be. I also know from reviewing the documents that the City Council had a prior intergovernmental agreement with the LRA, which was necessary because the city had to authorize the tax increment to be used to pay back the bonds. And the 1988 bonds, when they were refinanced, required that the IGA be, that a new IGA be adopted. And the new IGA was adopted at about the same time as these bonds were refinanced. So the council received a council communication from staff. I reviewed that. It was the city manager at the time. Admittedly, it was not clear in the written council communication as to everything that the new bond indenture would do. But again, I wasn't at the council meeting. I don't know what the discussion was. I do know from the minutes of that meeting that Councilmember Clark was here. It doesn't appear that there was any kind of detailed discussion about what all of the issues were. And I'm presuming, perhaps incorrectly, but I'm presuming that the documents that were relevant to the transaction that was being undertaken at the time were made available to whoever wanted to see it, who was involved in this decision. Council did approve the IGA, which authorized the continuing dedication of the tax increment to the bond repayment and to the note repayment if there was sufficient funds to do it, and in accordance with the terms of the indenture that would be approved by the LRA. And as I mentioned at the outset, the LRA approved the indenture, which said these debts are terminated as of December 31st, 2008. So, at least in my mind, the approval of the IGA, which authorized the continuing obligation and the new refinancing, was certainly an apparent acknowledgement and action by council that it was approving the terms of this new transaction, and it was aware of what the impact of these terms would be. You know, getting into the weeds as to what any council member actually knew or thought of or consented to when they voted yes to that IGA, I can't say. I don't think any of us can say unless we were there. But the documents are there.
Okay. All right. I appreciate that. If it's in a document or in a charter or in a protocol of some sort that we should have a sitting council member on the LIFT board, I guess I'd ask you guys to come back and advise that. I certainly have no problem with that. I think it's not an inappropriate utilization, and if we're not doing it so that we've got a liaison, I think that makes a lot of sense. But I guess then I get from my own accord as well, I would say that I'm not prepared to ascribe ill will to anybody that was involved back on the original deal or the intervening arrangements that occurred between then and now. I don't believe there's anybody on this council that has any intention or negative aspiration for the community, for the city of Littleton. Again, to Norm's point, I think we all want to do the right thing. My request of everyone would be that we all exhale and get more information and see what's actually being proposed and try to understand if it makes sense. If it doesn't make sense, we'll deliberate that and vet it and hopefully not do it. And if it does make sense, likewise, we'll vet it, we'll deliberate it, and hopefully we'll have an opportunity to do something that's in the best interest of the community. I think those are the motivations, and I think the community's best served by giving this thing a fair hearing as we go forward over time. Thanks.
Councilmember Cole.
Man, it's a tough act to follow. So something easy first. City Manager, are we proceeding to try to collect data on the births in the city since 2010 to augment the state demographer's presentation to us?
Yeah, Mike's working on that.
Okay.
Deputy City Manager is working on that,
Okay,
yes.
thank you. Then, with all due respect to what was just said by Councilmember Stallman and our attorney, I would really like to have a written report that responds to the issues that Mr. Clark raised. I'm not saying somebody's right, somebody's wrong, but I'd like to have something in writing showing whatever documentation, if there is any, on agreements relating to the bonds and the notes. But it seemed to me, and maybe I'm wrong, that he was raising some issues that relate to legal requirements of what can and can't be done. And so I'd like all those issues that he's raised addressed in writing. Then I'm anticipating, but I may be wrong, that might lead us to some kind of discussion related to LIFT, but which we could do at a study session. But I would request that, because this is I think important if we are moving forward with LIFT, that we have this clear so that nobody feels like somebody's trying to cover something up. So I view it as a confidence thing.
Mr. Mayor, when it's my turn, I'd just like to respond to that at some point.
Oh, you're done.
Okay.
Go ahead.
There have been times this year where an individual council member has made a request of staff and or the city attorney, which have led to significant expenditures and outlay of city resources. And to the extent that former Mayor Clark provided, I think, some of the documents that you may be discussing or requesting, I wonder if it wouldn't be appropriate for us to decide what level of response the city and the citizens of the city should be preparing to counter some of his questions or assertions. I think that Councilmember Stallman was very eloquent in his presentation, and so I would say that I think before we direct staff to, and particularly the city attorney, who, as we note, is on the clock all the time, to do that, I think perhaps we should have an agreement that it is coming as a directive of council.
How can I respond to that?
You want to respond to that?
Hmm?
You said you wanted to respond
Could
to that.
I hope
Can I make a question first? Would we have time for a discussion at study session next week after we have a chance to review the material?
You can always go later, yes.
Okay.
Give me 1 second. Let me look at that agenda again.
Next week, is that what you're saying? Okay, that'd be good.
First, a comment. At our last regular meeting, the city manager asked council if there were 4 of us who were going to vote for something that we wound up defeating tonight, because he pointed out there would be a lot of staff time going into putting together an ordinance. And 4 people said yes last time, but now we didn't pass that. So I'm very, very conscious of not wanting to waste staff's time. But the city attorney has already said that he's already done some investigation. It does not sound to me as though this is going to take that much more, but it will make clear, and maybe it will take more, I don't know, but it will make clear for everybody the responses on a very, very charged issue. At least it seems to me. I think it's worth it to do this.
I'll point to, does it make some sense to maybe have a discussion after folks, I'm going to give the homework here, so go out to the LIFT website, look at the PowerPoint presentation, recognize that where the LIFT board is itself, and read through the questions and answers, in addition to taking a look at Doug's material and questions that we've had at the last 2 sessions. Maybe those could be, I don't know, summarized, but if we had those as far as questions, I think we have Doug's 1, 2, and 3 from last night, but Linda and John had some others, possibly. And we could put that together as a structured conversation. this is not going to go quickly. There's still lots of steps that are involved. They haven't narrowed down any of the study areas to anything else in addition to that. It will have to go through the planning board before it even comes to council. So we have a lot of time. I think as Councilmember Stallman presented, it is a good time to take our breath because I think folks are dealing with hypotheticals. When it moves along, we'll have some specifics to actually deal with and talk about. But I think there are some questions that maybe we should get some issues or responses on sooner.
And the specific one I'd like to hear about is like spending of funds on new projects, and how does that match against the state statute?
Yeah.
That kind of stuff.
Okay. Does that work?
Okay. So, thank you.
Mayor Pro Tem Beckman?
I'm going to refer back to that discussion in a moment, but I want to talk about two other things. First of all, the Highline Canal had water in it for several weeks, and we certainly, it was created. I don't think there's been water like that in several years, but it was shut off over the weekend, and if you go by it today, you'll see that it's just got a few puddles. I am on the Highline Canal Committee that is doing everything they can to save the Highline Canal, all 70 miles of it. But I do want to point out to you that although, people took a breath and said, look at that, the cottonwoods are finally getting some water and things, that was a very temporary thing. It is still very important that you know that the jurisdictions all along the Highline Canal are trying to find ways to save that canal as best we can when Denver Water really isn't going to be using it much as a water transportation device, and the work continues on that. Other thing I want to mention internally here is Fine Arts Board is very interested in the wayfinding project and the gateways to the city that we're talking about as part of that. In the past, we did do, there may be more than one I'm suggesting, but at least two major art displays at entryways. One was Coming Home at Prince and Santa Fe, which everyone knows is the horses and the kids and the family coming home. And the other is, and I think it's Endless Sundays. I'm not sure. It's right at the entrance where Alamo and Main splits. I'm sorry. Month of Sundays, which was another entry. Year of Sundays. Let's get it right. I think there was some talk at our last meeting about maybe we could relocate those or refocus those to the goals that we have of identifying the outlines of the city and the entryways, particularly that Coming Home one, which is very, very, very cool. And when Santa Fe and Prince were remodeled, it kind of got lost there. And it's appropriate in a great spot. It's just the highway and the changes kind of overwhelmed it. And then the other one is the intersection of Alamo and Main. Maybe that fits or maybe it doesn't fit right now, but it's very cool, and the public should be able to see it and be aware of it. So those two, and plus any other opportunities that may arise, the Fine Arts Board is very interested in that. The last thing I want to mention is that Riverfront Authority issue, and I don't think anybody's arguing at all about the lack of success of the Riverfront Authority. It wasn't successful in meeting its goals, and it left a lot of things in its wake that really were not something that Littleton should be proud of. I was around then, and even during the opportunities, even when it was being seen in its brightest moments, believe me, it was not a kumbaya situation. There were businesses and people that were very concerned about what was happening, and along comes the economic circumstances that Councilmember Stallman talked about, and it kind of it fulfilled what their worst dreams were in which they had stated. So here we are. We're here with the circumstance that we have. I just have to say that anything that I've ever addressed, private property rights come first, and I think coming at it from that point of view will make a lot of difference in the way the outcomes are handled. So I just want to make that statement, and I hope that others share my deep concern for respecting private property rights. And finally, we've got this great intent to try to improve the economic situation in the city. We have to do it. If you look to all 360 degrees around us, you'll see that the communities that we're surrounded by are moving into new forms of commercial enterprise that are assisting them in being successful cities, and we're behind the power curve. It's not a sense of crisis, but it's a sense of awareness. And when you talk to them, and we talk to our peers in those cities, it's finding different ways of approaching economic vitality, including this, that are what have helped them be successful. So really it would be, the council wouldn't be doing its job if it didn't look at those alternatives. Looking is not buying, and those are two different things. So our best intent gets clouded by the lack of success of the riverfront, but our intent still is to do the best we can for Littleton, respecting private property rights and protecting those things that are important to us as Littleton citizens.
Thank you, Bruce. Just wanted to mention one other agenda item for us on June 24th. Make sure that you have the meet, eat, and greet, which is at the steeplechase section, right?
I have no idea. I won't be there.
We're going to be in your neighborhood. So,
oh, it is?
Yeah.
Is that one?
Yeah.
That's not what I'm scheduled for, I don't believe.
No, I'm not talking about the coffee. I'm talking about the meet, greet, and eat where we have pizza with folks. It's going to
Steeplechase.
I hate to correct you, but that's
okay.
not my district.
Okay.
Yeah.
Oh, that's there. Okay, I'm sorry. Got it. Okay.
Okay, man.
Yep. And then just to piggyback a bit on what Mayor Pro Tem Beckman had to say, really do appreciate Norm's comments on taking a look at going forward and being very careful. It's part of the reason why we've had a number of presentations trying to understand things from a 360-degree perspective with regard investors and developers and financing and understanding the benefit that everyone would be looking for from that, but very much looking at what the city can have. With this, recognize when Mayor Pro Tem is commenting, I mean, Southern Jeffco has a business improvement district that everyone is taxed for, and so they're taxed at a higher level there. What they've done with some of the urban renewal in Centennial and also some other taxing authorities and financing back that Douglas County has gone through, it's prudent for us to at least take a look at what could be and what the possibilities might be. I know that there's things that went wrong. It's interesting that 99 was just prior to the technology bust, and then 2008 was in the middle of what is known as the Great Recession at this point in time, and those are the recent pieces, but those were 10 years or more after even the project was put together to begin with. So we have a saying at the office, those who live by the crystal ball learn to eat ground glass, but life has risks with it, and so we need to have an understanding of what the risks are and place those appropriately. And I think there's been some guidance also at the state level with regard to legislation as to what urban renewal authorities can do, and that's a lot clearer than when Riverfront was put together. So we are following a stepwise process. As transparent as I think is prudent at this point in time, but also recognize it goes a lot slower. Speed of government is not very quick. I have found that out, and we get underlined with it. So be careful how far ahead of us you might want to be thinking. That's not to squelch your comments, not at all on that, but it's also take some breath and always interested in what you would see as the upside and the benefits that would happen. So.
If you let the snow build up, you eventually get an avalanche. And I think that's what folks are looking at right now. They're trying to do some work up front before we get to an avalanche.
Yeah, don't want to get to an avalanche.
Study session next time.
Yeah. So.
Study session next time.
Yes. And so
great.
We have that. So, okay. With that, anything else, Council? And we stand adjourned.
All right. Thank you.